As of right now, the no contact provision is going to be lifted.
There's a
And-
PPO
And
zone.
there's a PPO that prohibits contact with the children.
And not with the children.
Not with the children, just with my wife. And then the bond conditions for both of them were
They're
no
going to
contact.
be lifted. So
Okay,
you're
yeah.
going to be legally entitled to contact with your children. That's going to be very difficult because you've got to reestablish this. You're not going to get X'd out of the rest of your children's life because of this incident. But you're going to be on probation. You're not on a bond condition. There's a PPO that prohibits you from having contact with them.
Except for when we have pick up or drop off. It's stated in the PPO.
Yeah, all right.
And I do have plans for someone accompanying me to pick up and drop off, so there's no more incidents happening.
That's probably all for the best. Right now, I take them at their word. Your kids are afraid of you. They didn't like this. Yeah, yes. And you're gonna have to rebuild some trust with them. I'm not sure about the boys so much, but your daughter, this was frightening for kids. Let's talk about Darren Hodges.
Your Honor, okay, they've requested restitution for the fees for the kids for baseball.
That's a no. I might consider restitution for a broken phone. Tell me about that.
When Darren Hodges pushed me, he shoved
Well, I
me
haven't
on-
done Darren yet.
No, that's, I just, if there was
Yeah,
gonna
well,
be
my
any.
No, I'm
phone-
not gonna do restitution for, they all got kicked off the thing and they were all part of this thing. I may consider your phone, so
Yeah,
we'll take
'cause
that
it's
up.
totally
on the
broke.
next one. All right. All right, Darren Earl Hodges, the complainant in that case. Read her statement. That's Carly Swartz Friesen. And we got a number of letters on behalf of Mr. Hodges, one from Pastor Jerry Solis of Destiny Church and some other letters from people that he worked with. And character references. One thing is, I probably know Mr. Hodges better than the character references. When he was young, he was a frequent visitor here at the courthouse. He has at least 4 domestic violence charges in his past. Couple of malicious destruction of property charges and some other sort of things I won't get into, which are old. Pastor Solis told me that, and in the letter, he got connected with the Destiny Church about a dozen years ago or so. And I don't know that there's anything newer than that. So these people know him in the last 12 years, but he did have several assaultive offenses. One was deferred, one was turned into a disturbing the peace, one was some sort of other deferral. And, but he grew up, he had kids, got a job. Did you lose your job as a result of this at XL Machine?
Yes, sir.
Or you went to jail and they just terminated you for not showing up?
Well, it escalated through other things that they said I violated a policy at work.
All right.
But
All right.
I am employed now,
At where?
Cooper Damp and Waterproofing out of Middlebury.
Okay. Well, Mr. Mecrio, you know your client and this circumstance. Again, it was, nobody was willing to budge. It sounds innocuous enough. He's there with his granddaughter watching her game. She lives at his house. He's grandpa. Then everything went haywire. What would you like me to know?
Judge, I think you have a good grasp of everything that went on, and I think the fact that everybody was banned indicates that this was not an out-and-out attack or some sort of assault where somebody was totally victimized and run over with some sort of a criminal activity and had to be helped. This was a argument, this was yelling, this was screaming on both parties' ends, this was physical contact by both parties. But my client realizes what he did was inappropriate. And I think that's why he sought out the Pastor Solis, who is present in the courtroom here, showing his support, which I think is important and very telltale as to what kind of person Mr. Hodges is. He took responsibility, Your Honor. He entered his plea. He realizes that there was probably much better ways to handle an incident where his grandchildren and his son were involved in an altercation with a couple of women. He should not have touched anybody. He should not have put his hands on anybody. He realizes that. He's embarrassed as to how the community may have observed him that day and observed everybody that was involved in this case that day. I don't think it spoke very well for the way he wants his family portrayed. And I think that's why, Your Honor, he continues to work hard. He continues to seek employment. He now is in counseling. He's working with his pastor. He is stepping back, waiting to see what the family court does. It's my understanding the parties have a hearing in family court the 15th. So maybe something will happen in the next week or so that'll get the parenting time back on track and get everybody involved in a situation where they can communicate with each other without really upsetting anyone, realizing that the communication is for the children only and not for them. My client is prepared to do whatever the court wishes. I think incarceration at this point, Your Honor, would be unjust given what he's done and the 3 days he's already spent in jail. The court did make reference to his criminal history. I think that was approximately 20 years ago.
Well, the most recent thing he has on there, other than this, is 2014.
Yeah,
So I haven't seen him in 10 years.
Yeah.
I've seen him, but not here as a litigant in court.
and Your Honor would realize that if someone doesn't avoid that type of contact unless he's made some change in his life that are very positive. He loves his grandchildren. He loves his son. I'm hoping something will work out where he'll be able to continue his relationship with his grandchildren. But other than that, Your Honor, if the court feels probation is necessary, we would ask the court to consider probation and defer or not impose any jail term, Your Honor.
ChatGPT said, "All right, let's talk about that." This hearing was a classic example of how decades of family tension can flare up in one ugly public scene, and how a courtroom sometimes becomes the only place to press pause long enough to sort out the consequences. Darren Hodges was before Judge Middleton to be sentenced after what began as a family argument at a child's baseball game but quickly escalated into physical contact, yelling, and a scene disruptive enough that everyone ended up banned from the field. It was clear from the start that the judge knew Mr. Hodges well, if mostly in the rearview mirror, for prior domestic violence charges, property crimes, and other assorted troubles, though, to Mr. Hodges's credit, none of that had resulted. In new cases in the last 10 years, that history weighed heavily, but so did the fact that he'd apparently tried to get his life together in the years since finding steady work, getting involved with the church community, and supporting his family. Still, Judge Middleton made it plain that the past was relevant context for the present. A pattern of aggressive behavior doesn't disappear just because time has passed. Mr. Hodges's attorney struck a measured tone, acknowledging that his client's conduct was out of line, but pushing back on any notion that this was an unprovoked assault. He characterized the event as a heated mutual confrontation, yelling, pushing, and poor decisions all round, and stressed that Mr. Hodges had taken responsibility by pleading guilty without excuses. The defense also highlighted his immediate steps after the incident, reconnecting with his pastor, returning to counseling, and doing what he could to minimize further fallout. The prosecutor didn't need to say much to underscore that the children in the middle of all this were the real victims. Judge Middleton repeatedly came back to that point, emphasizing that it was terrifying for kids to watch their caregivers dissolve into public shouting and shoving. The judge also took care to distinguish between bond conditions, which were ending, and the PPO that would continue to control contact. He made it clear Mr. Hodges wasn't going to be cut off from his grandchildren entirely, but that any future interaction would require patience, structure, and trust building. In the end, the judge opted for a sentence that balanced accountability with a path forward. Mr. Hodges got probation with conditions: no assaultive behavior, compliance with family court and PPO terms, continued counseling, and no drugs or alcohol. The judge reserved restitution to consider compensation for property damager, broken phone, while rejecting reimbursement for less direct consequences like the kids' sports fees. Jail time was limited to the 3 days already served, reflecting both the seriousness of the incident and the defendant's efforts to show change. What struck me most was how calm and direct Judge Middleton remained in the face of such a volatile family dynamic. He didn't scold or humiliate Mr. Hodges, but he didn't sugarcoat the impact either, especially on the children who had to watch adults behave this way. It was the kind of hearing that reminds you court isn't just about punishment, it's about trying, however imperfectly, to break cycles of conflict before they become permanent. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read every one,